issues involving external shocks to the political environment and how this is affecting firms. And as a corporate governance leader, the Millstein Center founder, Ira Millstein, not only had a huge impact on board governance, he was really committed to generating meaningful dialogue on these issues of great importance. And so it's really fitting that today's conference in his honor is bringing together distinguished academics and practitioners in this independent forum for reasoned examination of this present environment, as well as what's coming in the future. So I'd like to thank our panelists for joining us to share their insights today, our partners at ECGI for their terrific collaboration, our AV and Building Services team for their support, our Millstein Center leadership team. I'd really also like to express appreciation to the Millstein Center Chair Emeritus, David Nierenberg, for his wonderful sponsorship and support. And David couldn't be with us in person, but he's going to speak with us virtually. We'll share in a few moments his video tribute to Ira and to all of, welcome to all of us. Before that, we're going to hear from Dean Daniel Ababa, who joined Columbia Law School in August 2024. He may be regretting that choice a little bit right now, but we're so lucky to have him with us as Dean and Lucy G. Moses Professor of Law. Before that, he was Vice Provost for Academic Affairs and Governance at the University of Chicago. And he was previously the Harold J. and Marion F. Green Professor of Law at the University of Chicago Law School, where he served as Deputy Dean from 2016 to 2018. Daniel Ababa is an elected member of the American Law Institute, a member of the Board of Trustees of the Higher Learning Commission, and a member of the Board of the Knight First Amendment Institute. So, Dean Ababa, the floor is yours.
Morning. Good morning to everyone. And thank you, Professor Lund, for the introduction. I'll just confirm to everyone here that I'm thrilled to be at Columbia Law School, and that feeling has not changed. So thank you, Dorothy, for giving me the chance to say that. It's wonderful to have all of you here in attendance, both on campus here in Morningside Heights, and of course to all of you who are joining and watching over Zoom. I really appreciate, Professor Lund, the opportunity and the invitation to offer a few thoughts this morning to open today's program, which we host, of course, in honor of the late Ira Millstein, a 1949 graduate of the law school and the founding chair of the center that bears his name. As some of you may know, Ira agreed to participate in a series of interviews with Columbia's Oral History Project in 2021. So in nearly 300 pages of transcripts, Ira offers his own memories of his academic life, his legal career in antitrust and corporate governance, and his ever-present service in and to civil society. So when Ira was asked, excuse me, for his reflections on how he chose to spend his time, he shared the following, and I quote, "Yes, I could have played a lot of golf. I could have played more tennis. I could have done a lot of other things, but they never scratched the itch that I had in being called upon to help, to do something to make it work. Even in the private sector, when I got into a case, I liked the idea of figuring it out. Why is this like it is, and what does it need to solve it? That's what I like," end quote. So finding fulfillment in the quest of figuring it out, in raising your hand to tackle the toughest questions, in collaborating across fields to evolve and advance ideas, all of these lessons, at least for me, leap off the pages in Ira's words. And in convening events like today, in today's conference, his eponymous center, I think, carries that legacy forward. So in looking at the impressive slate of leaders in today's program, legal scholars and practitioners who are at the vanguard of their fields, I would venture a guess that these are the traits and personality and the temperament of many of the people who are here. And I assume all of you share those traits. And I'm really honored that such distinguished voices are present and here at Columbia Law School and are part of this conversation as active participants in Ira's, I guess, his beloved vocation of making things work. So I want to extend my thanks as well to Erica Klein and Molly Calkins for their efforts in organizing today's events, to the European Corporate Governance Institute for their partnership as well, and finally, of course, to the faculty leadership of the Millstein Center, Jeff Gordon, Dorothy Lund, and Eric Talley. Thank you very much, and I hope you enjoy the conference.
The folks of the first panel come up. Are we here? What? Oh.
It's my pleasure this morning to welcome you with this eulogy for our founder, Ira Millstein. We first met in 2006 after I'd been engaged in board governance for 2 decades, prodding companies and not-for-profits to improve their governance. I connected with Ira through a gift I made for corporate governance to the Yale School of Management, where Ira was teaching that very subject. The gift was to create a permanent governance organization there named for him, and also to endow a governance chair named for my father. Over the next 18 years, I served on the Millstein Center's advisory board as Ira's vice chair, then as its chair, and now as chair emeritus, first at Yale and now here at Columbia Law School. Through this partnership, Ira became my mentor, dear friend, and virtual second father. Partnering with him, I learned this key lesson: just let Ira be Ira. Sometimes our colleagues forgot that, believing mistakenly that they were not supporting actors, that instead their job was about themselves or about their personal agendas. Not so. When you were blessed with the opportunity to serve a living legend, your mission should be to make it as easy as possible for that person to do what he thinks is right. Check your ego at the door. Certainly, Ira permitted, even encouraged, questions, suggestions, and disagreement, but it was obvious to me, even in a governance organization, that Ira's name was on the door and that his name belonged on the door. When Lord Acton said that power corrupts, and absolute power corrupts absolutely, he did not have Ira Millstein in mind. So today, I share 6 reasons why Ira's name is and remains on the Millstein Center. First, Ira invented the board governance movement and then refined it over the next 4 decades. His book, The Activist Director, tells war stories going back to his pioneering days of advising the board of General Motors about its governance responsibilities. This is what he wrote in the introduction to that book 8 years ago, when he was then 90 years old. Quote, "Many directors still don't understand their roles and responsibilities as fiduciaries. We need a fundamental change in corporate leadership. Passivity must become the past. We must elect directors who will steer our corporations to be the vigorous competitors they are capable of being, able to attract long-term capital." I wrote this book to drive a stake into passivity. The key to breaking this unvirtuous circle is, I believe, how the corporation is governed. The solution, I believe, is not more regulation. I will build the case for adopting a board-centric approach to corporate governance by placing more activist directors in the boardroom, people who will ask the tough questions, challenge management practices, and resist those who put their own agendas ahead of those of the corporation and investors. Choosing directors will require new diligence and care. Some will call this pie-in-the-sky idealism. I prefer to call this pragmatic optimism, unquote. Second, to this movement and to himself, Ira attracted and retained superb colleagues from diverse and relevant backgrounds: lawyers, investors, activists, proxy advisors, board members, public servants, academics and students in law and business, CEOs and not-for-profit leaders. Third, Ira mentored hundreds of people like us, maybe even thousands, by listening thoughtfully and empathetically, counseling us and helping us grow. Fourth, with his unparalleled network of relationships, he was a magnetic convener. Everyone returned his calls. Fifth, Ira lived to be 97 years young, not old. He remained curious, creative, intellectually agile, self-critical, constantly thinking and learning. As the movement he created grew large enough to become institutionalized, he never became an inflexible founder. Rather, he became openly critical of evolving errors in the movement, such as what he disparaged as, quote, box-checking compliance idiocy, unquote, and excessive rulemaking and regulation, which crowded out solid business judgment and wasted board time. Finally, Ira never became a wild-eyed radical. He adhered to common sense, seeking the common ground for the common good. He was a realist, a pragmatist, not an ideologue. He knew how to disagree without being disagreeable. He was a capitalist, an idealist, a pragmatic optimist. Ira's Millstein Center must carry on because the immutable flaws of human nature, pride, pursuit of power, status, and wealth, require constant vigilance and thoughtful engagement. Because of our flaws, executive compensation, board governance, resource allocation, and accountability require ongoing activist oversight. The specific abuses will change, the players will change, but our human flaws do not change. As the French cynically observe about changes in leadership, they say, same shit, new flies. Concluding words to describe Ira might be pioneer, teacher, mentor, mensch, catalyst, public servant practicing tikkun olam, which means mending the world. We thank Ira for making Columbia, New York City, New York State, our country, and our world better. May his namesake endure at least as long as he did. Thank you for joining us this morning, and may you all be inspired by Ira's exemplary leadership. It's my pleasure this morning to welcome you with this eulogy for our founder, Ira.
We're now ready for our first panel. I was the faculty co-director at the time that the Millstein Center came from Yale to Columbia. And much as David has said, Ira was really an inspiring presence. I can't but think how things for Columbia might have gone in a different way if he had been in his prime and able to advise the board about how to engage. And I also can't think but the concern Ira would have had about the response of the legal profession these days. But and one of the remarkable things about him as he approached 90 plus years, the Fleetwood Mac song that some of you may remember, made famous by the campaign for Bill Clinton, Can't Help Thinking About Tomorrow. That was Ira. You know, as however old he was thinking about the next thing, the current thing, the next thing. And that's, you know, a remarkable model. as how to keep alive and intense, I think, throughout the whole life. Anyway, so we now turn to the business of the day, and I think the day is really a terrific day. Some traditional stuff by the law professor crowd trying to understand developments in the world, and then we engage more directly with developments in the world. So today's panel is relational investors, PE investors, and shareholder control agreements, and it's going to start off with a paper by Gabe Rauderberg, a professor at Michigan, formerly an academic fellow here at Columbia. So we collectively take great pride in where Gabe has gone with his work today. And then the discussants are going to be a pretty good mix of the professor crowd and otherwise. Brian Brauman from Vanderbilt, Elizabeth DeFontenay from Duke, who is zooming in because she was on a plane with mechanical delays, and they made the wise choice to get everybody off the plane. So she's going to be on Zoom. And then Elizabeth Cooper, who is a partner at Simpson Thacher, about Elizabeth. She is perennially a deal maker. She is a co-head of PE work there at Simpson. And I have students who are deciding to go to Simpson precisely to work with her. So that's a pretty good accomplishment, I think. Anyway, so Gabe, why don't you start us off, and then we will proceed in order.
Okay, I'm Gabe Rauderberg. Thanks to the organizers for inviting me. Thank you all for joining us, and thank you especially to the family of Ira Millstein. It's hard enough to have a long career at the height of practice. It's rarer still to combine that with a far-sighted interest in the future of corporate governance. So I'm very much pleased to be able to join at this conference celebrating his memory. So I'm going to talk about the increasing and/or changing role of private equity in our public markets. There's a well-known intersection of private equity and public markets that goes back 50 years to the first buyout funds, which is private equity firms take public companies private. They also roll up and transform private companies and sometimes take them public. And I and others have studied the corporate governance associated with that going public process. Private equity funds can sometimes own companies they take public for several years afterwards. They can enter complex and interesting and occasionally controversial shareholder control agreements to structure the governance of those firms as they wind down their ownership position. But it's been a commonsensical view among some of us that that's about it. That the role of private equity in public markets is confined to newly public companies, that mature or already public companies, they play little or nothing of a role. In fact, I'm guilty here. This is a primer on corporations that I wrote with a bunch of friends and co-authors. And we say PE funds take public company private. VC funds invest in companies before they're public. They don't have significant roles in the stewardship of public companies. And that hasn't been true for the last 15 years. It probably was true 20 years ago, that piece of common sense. But there are two main empirical ideas in this paper. One is to show the significant footprint that private equity has had in public company equity raising over the last 15 years. And the other is to try to conceptually characterize it as a form of interesting governance, that actually there's a significant element of relational investing to how private equity firms have acted as owners of public companies. This relates to two different debates. One is a very long-standing debate in corporate governance. Probably the central obsession of corporate governance has been how to mitigate the separation of ownership and control in public companies, how to make sure they're less undergoverned. And one of the major candidates for that has been the idea that there should be institutional shareholders in widely held companies that play more of a role in governance. And lots of people here have played an important role in those debates. So that's one debate. The other debate is a more recent one, catalyzed in the Moelis decision from the Chancery Court and in the Section 122(18) amendment that displaced it, which is about how corporations should reconfigure the structure of control, how they should reallocate board authority, if at all, and what the mechanisms or altering rules they should use to do that. So those are the two kind of main empirical ambitions of the paper, is to inform those two debates. All right, first, the PE footprint in capital raising. So I could have put in a trend line here. There are some serious ups and downs, but this is just looking at the largest private equity managers that invest in pipes and the total amount of money they've invested over the last 25 years. And yeah, in the 2000s, there wasn't a large private equity footprint in the world of pipes, private investments in public equity, essentially bilaterally or multilaterally negotiated transactions with public issuers to finance them in a variety of complicated and heterogeneous ways. And here, using data from the Federal Reserve, I simply depict the amount of money being raised by public companies from seasoned equity offerings, that's just a registered offering of equity by an already public company, against pipes, equity-linked securities, as they're often called. And the green line is pipes in which a private equity or venture capital firm plays a leading role, and the orange line is other pipes. So venture capital is a small fraction of this. The vast majority of this is financed by private equity. And as you can see, private equity has come to play a significant role. The years 2019 to 23, which were kind of the apotheosis so far of private equity's role in public company capital raising, they were responsible for about 40% of all pipe by dollar amount, and about a fifth of all money being raised by public companies, at least using the SEO data from the Federal Reserve. So that's a big piece of equity being financed by private equity. Here's a simple illustration. So during COVID, Expedia is going through some serious distress. Apollo and Silver Lake, two large private equity firms, obviously step in and lead a capital raising round by Expedia. So Expedia raises about $5 billion, $3 billion in straight debt, $2 billion in complicated equity and debt linked securities, from $1.5 billion from Apollo and Silver Lake. And executives of Apollo, so Greg Mondry, one of the co-heads of Silver Lake's practice, and one of the co-heads of Apollo's private equity practice, joined the board. And this is a huge success story for Expedia. You know, Expedia's stock price almost immediately goes up from this vote of confidence and infusion of equity. And Apollo and Silver Lake eventually exit their position, in part through having their perpetual preferred stock redeemed by the company itself. So private equity plays a big role in public markets. They provide a big role in supplying capital. How should we think about this role? Well, one candidate for how to think about it is the idea of the relational investor, an idea that's been around for decades, with three basic components to it: significant ownership position in the company, a commitment to an extended duration of holding, and engagement with the firm on firm business policy. This is obviously the paradigm of engagement between institutional investors and companies in private markets, where this is the norm. It's also something that widely held mutual fund families systematically forgo. So they choose not to have these forms of control, participation on the board, access to non-public information. And I think we can think of this as maybe one of the central differences between private funds and mutual funds, which is one class of institution thinks, if I don't have access to material non-public information and a board seat, why is it worth calling control? And the other type of institution has no interest in exercising that. So the central theoretical question is private equity for some reason an interesting candidate for being a more engaged institutional investor, even in public companies, than registered funds? Well, private equity funds enjoy the generic structural advantages of private funds. They don't have the conflicts of interest of being Vanguard, who owns 8% of almost any public company. They lack the conflicts of interest we associate with pension funds. But there's also a bunch of reasons more specific to private equity to think that probably more of the advantages of the private equity model than you might think can be ported over to public market. So this includes concentrated, even majority ownership, expertise in running companies that can be industry or operational specific. A lot of the private equity playbook can probably be used in public companies, including heavy use of leverage, the ability to overcome information asymmetries through engaging with the board, redesigning managerial incentives. Obviously, there's not going to be sole ownership because that would involve going private. It also it raises new questions about how PE will exit these positions. So I think that's kind of an open question, how much of the playbook ports over. So how much of this is true? Well, based on the normal size of the private equity sponsored placement, I think a lot of it's true. So we can look at the average or median size of a PE pipe, and it's a significant event in the life of the issuers. These are obviously significantly smaller companies than the median public company. This is not the S&P 500 generally that PE funds are doing pipes in. It's the smaller tail of public companies, or the smaller third of public companies. So 40%, 20% median. Even if you think that some of the pipes often involve 2 or 3, lots involve 1, but that's still even at 20% an enormous equity percentage that's being given to these investors. And the duration data is really hard to get at, actually, because the typical way for an academic, at least, to determine how much an investment manager owns in a public company is so-called 13F data. But a lot of the securities that private equity funds get in pipes are bespoke. So maybe the central difference between a pipe and a seasoned equity offering, or one of the central differences, is the ability to enjoy indefinite customization. And so the securities involved in these pipes have extremely complicated customized features, downside protection, as well as upside potential through a combination of warrants, debt-like features, redeemability, and also convertibility to common stock. But using a sample of 367 pipes that I'm able to get data on, I calculate an average duration of 3 years. I think that probably understates things somewhat, because a lot of the common stock is actually not registered immediately. So I suspect it's somewhat longer, but I present this fact somewhat queasily, because I think it's a very complicated exercise to try to figure out the average holding period for a PE pipe. What about engagement on firm policy? Probably the most interesting question, at least for us as academics. How do private equity firms behave as shareholders, and what are the consequences of that behavior? So I and my co-authors continue to try to look into this. Right now, we focus on the formal structure of control rights. And we find what is to us some fairly interesting results, which is about 250 so of our total sample of PE and VC-sponsored pipes. 20% or so involve obtaining board directorships. So you get 1 or more, sometimes a majority of the board, but one or two would be more normal. You get the right to obtain a directorship on the board, and you get a bundle of veto rights. The veto rights are actually pretty modest and sensible. They usually involve the ability of the sponsor to prevent the company from doing something like issuing a more senior class of preferred stock, or changing the charter in a way that is specifically adverse to the preferred stockholders. But the rights are structured in extremely interesting ways. So this is I think a fairly paradigmatic example. This is Silver Lake investing in AMC. It obtains the right to place a director on the board. It's structured through the actual purchase agreement in the pipe. This is the exact kind of provision that the Moelis case held to be under a shadow of unenforceability or invalidated, and that 122.18 resuscitates or holds to be lawful. So during the debate around the 122 amendments, the claims were made by some of their advocates that the Moelis decision had actually invalidated hundreds of live contracts. So they were, and in a sense, one of our major findings is that's true, that there was, but beyond the Moelis contract itself was a pre-IPO shareholder agreement. It was a contract among pre-IPO shareholders that governed the company as a public issuer. That's one major universe of contract that involved these kinds of contractually secured governance provisions. I think, as far as by my lights, this is the other major universe, which is agreements, which is pipe agreements, where there are hundreds just involving private equity firms, and then a smaller incidence involving hedge funds. where private equity sponsors are contractually securing the ability to have a director designated to the board and a commitment by the issuer for their board to recommend the director to the shareholders for election. You can also structure this through preferred stock, and we see this sometimes too. And Moelis, in a footnote, explicitly held this to be the preferred way under the pre-12218 law. The idea that you could always have a preferred stock certificate of designation where the board used its blank check preferred stock authority to create a new class of preferred stock. Okay, there are also a bundle of veto rights. As I said, I actually think they're pretty modest, at least comparison to Moelis itself. We also see voting agreements. They may trouble some and others may find them completely innocuous. But we see in something like, in a highly significant fraction of the contracts that involve the creation of board seats, we see the receiving sponsor agree contractually to vote for the board nominees suggested by the incumbent board. Sometimes to vote for them on as the board suggests in a variety of other matters. You might think this is an anodyne standstill agreement. This is just agreeing, we want to come to an agreement. We want to allow you to join our company. You need to agree to support us. Or you may be troubled by this. Kant's categorical imperative I don't think this would hold up. We wouldn't want every shareholder to be contracting with the board to vote as the board suggests. It would render the significance of the shareholder vote in some sense unnecessary. So the voting agreements, I think, when I discuss this research with my students, they're quite troubled, and I have to be like, well, no. Maybe it's completely innocuous. So I have a hard time coming to a total final view on this. I don't want to take up too much of her time. So financial characteristics of the issuers, these are a relatively small set. The PE sponsors are investing in a small number, in a specific set of ones. What about how does the market react to this? Do markets like these agreements? Well, there's a long-standing result in the finance literature, which is that the market reacts negatively to seasoned equity offerings under the perception that they're desperate. And there was a long-standing result from 20 years ago that even pipes were associated with negative results. That's faded a little over time as the pipe market has evolved and been transformed. We have two different event studies. We run an event study on the announcement date when a company first mentions it's negotiating a pipe. This feels to us like the most natural date. And we see an economically very modest, statistically significant, small positive result. Looking at some of the pipe literature, I saw that sometimes people run the event study on the actual closing date when the pipe closes. So I did that too. We see actually a really large positive result here, the kind of result associated with the disclosure of hedge fund activism around a 5% cumulative of normal return. So, I present this somewhat queasily. I want to run a bunch of robustness checks on this. But markets seem to respond quite positively to disclosure of these PE-sponsored pipes once they actually see the terms involved. So I'll close out by talking about some of the implications and next steps for this project. And then I'm very much, Elizabeth and Brian have already sort of started to tell me about the fascinating world of pipes from inside practice. And I think we're going to have a lot of fun, and I'm going to learn a lot for sure. So what are some of the implications? This is preliminary research. There's not a large literature studying PE and pipes. But I think the evidence so far suggests that this is not something to worry about. This is something to learn more about. That actually private equity funds seem to play an interesting, useful, highly engaged role in the companies they join. It informs the Moelis and altering rules debate. It doesn't settle it. I have my own strong views on how that played out. But it does tell us that some of the claims about the significance of the decision were true, that there actually were large classes of contracts that had been contractually securing things like board designation rights and veto rights. Lastly, it raises some interesting questions about the nature of the relational investor problem, the kind of companies in which we might expect to see institutional investors playing a more prominent role. And there's some features to pipes that I just didn't expect. So the average issuer that's the subject of a pipe is the subject of more than one. It almost has a syndicated feel to it, something like venture capital investment in private markets, where you see issuers serially engaging with a PE-sponsored pipe market. And And that raises interesting questions as to what exactly is going on here. Pharmaceutical companies are largely overrepresented in this data. Are they having large capital raising events serially that they want to turn to the pipe market too? The next steps for us are to try to look more into what private equity firms are doing. Do they change the nature of corporate governance events? I think the answer is almost certainly yes for things like greater board turnover. Is it greater CEO turnover? Do we see changes to the incidence of M&A transactions? Probably, and the compensation of PE funds too. Okay, so thank you so much for hearing. I'm very much looking forward to everyone's thoughts, and I'll turn it over to Brian and Elizabeth. Thank you.
First or not sure. Okay, my first or. Okay.
So, go ahead.
Okay, thank you. I think I need to share my slides. Hang on and see if I can handle all this. Hi, Elizabeth. Where? At me. I think so, yeah. Hopefully I did that right.
Good.
Oops, I minimized Elizabeth to 90 point. Well, we can bring her back. All right. Well, thank you, Gabe, for an awesome project, and Vartan and Jeff too. This is a really fun piece to comment on, and so I'll jump right in. Let's see how to get that to move up. There you go. Okay, there we go. So three main contributions. I'll hit this really quickly. The first is just private equity showing up in a much bigger number than I think we'd often thought before. I think that fact by itself is interesting to people who maybe don't pay quite as much attention to this area. The other contribution, the second big contribution, I think, is the conceptual case for the private equity firm or private equity partner as a type of relational investor in public companies. And Gabe went through a couple of these: significant ownership, long-term investor, and engagement. And I think the case for this, the conceptual case for this, I think, is quite strong. The third contribution, I think, is the idea: is this actually happening? So the empirical support here. Do PE firms act as a relational investor through pipes? And here we have some evidence in support of it, some control rights suggesting that at least 21% of the time they take a board seat, veto rights sometimes, and we get positive short-term abnormal returns associated with them arriving. So I think my big question that I want to focus most of my comments on is, do the PE-backed pipes improve governance? And I think the first reason to get a little bit suspicious is this right here. And this doesn't mean, it might just be that there's a lot of heterogeneity in what these pipes are. And it might be that, and I think they actually just mentioned this in the paper, that many of them may not take much control at all. So the modal pipe, for instance, does not involve a board seat or does not involve veto rights. And I think that point should be made a little more clearly. So let's focus though on the subset that do, and see, in that case, can we build the argument for them improving governance and do this kind of relational investor type mechanism? Here, I still think there's reason to be a little bit skeptical, because I think an alternative story is just a selection story. That something like the following: the PE investor is skilled at finding undervalued distressed companies, and when they arrive, that signal is a positive one to the market. A couple reasons to back that up. The existence of management fees, carried interest, is a sign that they're probably getting an above market return on this. Investors, the rest of the market, should see that and should say, someone who knows what they're doing thinks they can get better than normal market returns, we should bump the price. Also, the fact that they have an extended holding period makes that signal more credible. So a standard, just like kind of model, assuming they do nothing in the realm of governance, these facts alone, I think, could explain a large part of the data on positive abnormal returns around their arrival. And I think, moreover, this is kind of a point from the pecking order theory for finance. If the firm truly needs money and is perhaps a poor candidate for debt financing, and I think the pharma industry or various health sciences companies fit this world pretty well, because they may not have the sort of either cash flows or collateral for borrowing, then the negative signal associated with doing an equity offering is much weaker than normal. So then we might be more comfortable going forward with a pipe, and the idea that it has a positive effect on pricing makes a lot of sense. What I would really encourage, and it sounds like from your last slide, some of this isn't in the paper yet, and I realize this is preliminary. I would encourage more to try to disentangle whether this is a governance story or a selection story or both. They aren't mutually exclusive. In fact, I don't think there's any reason the authors here need to argue against selection, but just try to find some more evidence in support of a relational governance story. A couple different ways of doing this. Look at the CARs, the cumulative abnormal returns for PE pipes with and without board seats. Are we fine? You could measure, and it does look like there's a slightly higher return there, but if you could find these as being significant, that would really be useful. This Billet study seemed to find much larger ones when they took board seats. It's old data, so there's more recent stuff here. But if you could find any of those sorts of stories, that would help. One suggestion here that it sounds like on your last slide, you're already doing a little of this, is trying to find non-financial measures of PE engagement and governance. So that might mean, how long does the director stay on the board? Do they actually take a board seat? Just getting a right to do this doesn't necessarily mean they're going to show up. Or CEO turnover, board turnover, restructuring, any of these things that we could show as being correlated with the PE pipe, I think would be really quite useful for telling the governance story. You could also look at long run buy and hold returns rather than just looking at the short-term window. Assume that you bought and held for a year, 2 years. If it truly is a governance story, I would feel a little more, I think there's more argument to believe that those returns might show up later and the long run story might be a little more positive. And I know that some of so Iliev and Lowry, which is a study looking at VC in a very similar sort of model, it's probably the closest study I think to theirs, does find these positive long run buy and hold returns. I think that'd be really useful for you guys as well. A couple of implications for what I'm going to call the public-private divide. I had this at the end of the introduction, kind of this contra Jensen story, where the normal view would be we have two worlds, public and private. To get access to public liquidity, you have to agree to the public company governance structure with all of its warts and all, including the separation of ownership and control. To get out of that in the Jensen world, you would go private. And I think what we're starting to see a lot over the last maybe 15 years is what I'm going to call more hybrid creatures that are kind of sitting on both sides of the public-private divide. On one side would be large private firms with nascent secondary markets for liquidity. You can think of Stripe as an example like this. There's actually quite a few of them in the kind of decacorn plus kind of world that are doing this. You could also see then where their story is more on the public company with a private style governance arrangement. And this has become much more common now. We have controller arrangements, the Moelis type story, governance by contract. And the law seems to be moving in a way that's a little more welcoming of these. And I think you could see this data as being one piece kind of that picture. But it does raise a question for me. If you truly want relational governance, why not just take the company private? And the paper tries to make the argument that this is an equilibrium point. It might be. But for it to be an equilibrium, I think I want to know why. Why stop here? I would think you would get more relational governance if you just take it private. So are the pipe firms really bad candidates for a buyout? I think Elizabeth here might have a lot more data on this, showing how different types of PE funds might look at this differently. Is there some sort of substitution? Are they looking at these kind of differently? I think having some story on that would really help. A couple other thoughts, kind of maybe quibbles. The cars, I was really surprised at how small the cars were in absolute sense. And it sounds like Gabe is as well, like 0.09% for a 4-day window. And that seemed really small compared to other studies that Iliev and Lowry find like 4.8 to 7%. These are like multiple orders of magnitude off. And it made me think that there could be a very simple explanation, which is somehow in your code, an accidental divide by 100, which is what you do when you're worried about percentage versus regular returns slipped in. And I would just double check that. Part of the reason for saying this is all the results are significant at the 1% plus level, at a very, very high level of 1%. And that seems unlikely to me if you're truly getting 0.09% type cars. The result at the end showing that the cars were bigger in a based around the closing date, that seemed more online with what I thought the other results were saying. Finally, I'll end with another piece that I think is supportive to you. This is from my own research with Elizabeth Pullman and Ifat Iran. We look at dual class VC-backed firms when they go public. And one of the things we found in that study that we're trying to explore in future work is the VCs often take a very large, they take a dual class position as well. It's not just the founder. And they continue to hold that for 3-4 years post IPO. And in fact, most of the dual class firms are really VC controlled more than founder controlled because they have like a 40-50% voting stake. and they exit much more slowly, which I think is similar to the Jenkinson study on like the long goodbyes. I think it's another piece that's very consistent with this. I don't know what they're doing in terms of governance, but I think it fits your story well. I'll end there.
Wonderful. Thank you, Brian.
Oh, I'm going now? Yeah.
Elizabeth, back up.
Okay. You put Elizabeth.
Oh, there she is. Okay. Awesome.
I don't do slides as a practicing lawyer. It's been a while. But if I was telling them I would have had to like staff an associate to do them. I don't know how to do slides. Anyway, this was really interesting for me. I haven't actually like read a paper since I was in law school 24 years ago. And so when I read this and I thought about like my world and what happens when a client, and I don't call them PE firms, I call them sponsors, but when a sponsor calls me and they want to do a pipe, why are they doing it? Right? The part that when I read the paper, I was like, you can't look at pipes uniformly. A lot of times a sponsor is doing a pipe for one of two reasons. And so I think getting more information on what was the background of the pipe, because a lot of times in my world, and again, at Simpson, we do larger deals. Most like my practice is larger, it's the bigger sponsors. And a lot of times we were doing pipes. When I look at the pipes I've done in the past 4 or 5 years, it was one of two things. It was either an acquisition financing, right? Where they wanted to do an acquisition and they needed money, and it's much simpler to do it with a negotiated private deal than to do an offering that has market risk, timing risk, especially when you don't know whether the deal is going to happen. You know, you don't know exactly when the wide offering would happen. And so therefore getting the PE firm up and running, it also gives you credibility. And so a lot of what we were seeing in pipes were actually the acquisition financing. So I would think looking at like, is there a subset of pipes would be interesting in that sense. The other reason we do pipes, as you say, is to help financing, right? And most of my clients think of a pipe more as a debt financing than an equity financing. So when you think about governance, we actually don't think of ourselves as relational investors because we don't think we're perfectly aligned with public common shareholders, right? We're in a different type of security. We're looking at this. Sorry, I'm saying we because that's all I do is work with sponsors. But we're kind of looking at the pipe as I said, as debt financing, as not pure alignment with the equity investors, because as you say, pipes take lots of different forms, and the form of the pipe is really driven by the capital structure of the company, what their existing debt structure is, what they need their ratings to be. Right? Because a lot of times these companies are in distress. And so putting incremental debt on it may have a kind of ratings impact, whereas being able to put equity in with some, a pref or something, it's going to have a better ratings impact. And so one of the reasons, the other thing that I thought would be interesting to look at is like not just the market reaction, but the ratings on the company reaction. Like, is there a ratings, like what part of the reason why you might see a benefit to the market is because it may actually like maintain a rating because of how they structured the pipe. So the other piece of like what is the market reaction is also like the ratings and looking at the overall cap structure of the companies who are doing pipes. But as I was saying, we often look at them as debt. I think the other piece that why do you see more private equity in the public markets? You just see more private equity generally, like fundraising and both private capital and private equity. That was the other thing too, is there's you were talking about private equity and Silver Lake, I'll just use as an example. The same funds that do a control investment, right? The funds that take the company private are not necessarily the same private equity funds that are doing the pipes. They have like a private equity firm that looks at a company, has different return thresholds on a control deal versus a pipe. And so it's not always the same deal teams. Some companies it is, but like, for example, I think I said one of the deals you talked about, the Silver Lake deal, that's made out of their Alpine fund. This is public because there are public filings around us, so I can say this. Silver Lake does their pipes out of their Alpine fund. And when private equity firms go and market these funds, they market them to investors with different return, right? Like for a pipe, a private equity investor is looking for a minimum of a 12% IRR, generally speaking. And so when they put the terms of the pipe together, they want downside protection, they want dividends, they want to change a control premium, they want make-whole protections, right? Versus, so you're asking I think, Brian, you were asking why does someone do a pipe versus a control investment? A lot of times we look at a control investment where we need a return of 20, 25% and can't make the math work. And so I've had lots of deals that go, oh, we would rather take it control, but we can make the pipe work on the numbers, but we can't make a control investment work. And so the other thing that I'd be curious, and you're not gonna be able to see this necessarily in the public filings, is to your point around like, how many deals do a pipe and then kind of followed by a control investment? Not that many. But it is interesting that they're looking for different returns on like why they would do a pipe. On the governance piece, the relationship, like we don't think of the veto rights as being anything other than protecting the terms of the security. So when you talk about kind of relational governance and like what they're doing, I actually think the biggest impact is on the board seat. Because for the private equity firms that take board seats, the thing that is not in the literature is most of the private equity professionals are really sophisticated board members and can add a lot. So I think looking at like, are there changes to the capital structure? Are there changes to the strategy? Post, I think would be really interesting because I actually think one private equity director, the part where I did really think there could be a big impact is the role of the director and kind of how it is different when they take the director seat versus not. Because when I've been in boardrooms with a private equity director, they are much more active. They have views, they have relationships with other firms, right? Like, are they doing more M&A because they know the industry and they think of really good targets? Obviously, they have sophisticated cap markets groups. And so they think about, should I have a better financing structure? So I do think looking at that piece of it is really interesting because that's where private equity really does add, is in, you know, in a minority investment, they're not going to have a lot of operational influence, but they could have a lot of big picture board strategy influence that I think would be interesting to look at. What my other, I think the last thing that I want to talk about was a little bit of the what was it last? I think that was mainly it. I think, oh, the one thing I wanted to just say, and it's not for this paper, but generally when I told my partners that I was talking about private equity in public markets, they were like, oh, you're talking about retail funds. And so the one piece I just wanted to say that when we think about private equity in public markets generally, less on the paper, but generally speaking, I think we're going to see more because private equity, they're actually opening themselves up to the general kind of shareholders. And I think as the retail funds grow bigger, you actually are going to have more private equity fundraising, more uses, more capital that needs to be deployed quickly. And I think public companies and pipes are a natural place for some of this fundraising that's happening in the retail fund. So going forward, it's happening right now, so you probably need a few years for it to happen. But I do think going forward, thinking about like the different types of fund structures and different fundraising and how that's going to impact it in the future.
Wonderful, thank you.
Yep.
Okay. I'm just want to start off by saying that I am so sad not to be here in person with you all. As Jeff Gordon mentioned, I spent a long time on a plane this morning. It just sadly was not actually in the air. So, but I got a breathtaking view of the tarmac. But in any event, I am really regretful not being there to see many, many friends in the audience. I'm thinking of you, Jeff Tabak, in particular, but also my, folks that I think of as colleagues at Columbia, the world's brain trust of corporate law. Just very sad not to be there with you all. But nonetheless, we will proceed. So I am going to share my slides, and please let me know if for any reason you can't see them. So my main reaction is that this is a fantastic paper and a very welcome contribution to the literature in this space, because it's undeniable that we are at least partway through some massive, massive, just dramatic changes to the public markets and the private markets, what they mean, what role they play, how large they are, and so on. So just to put that in a little bit of perspective, it has become very obvious that much more capital is raised in the private markets, and this is just equity capital. Much more equity capital is raised in the private markets than in the public markets. The change here has been very swift and fairly staggering. And that if, in fact, it is increasingly rare for companies to raise equity capital publicly, and it is certainly rare for them to do so once they are already public, as Gabriel mentioned. In addition, we have seen a big change to the public markets in terms of what companies are public and how many. So we have had a major decline over the last 30, 40 years in the absolute number of public companies. Has gone down by more than half. Even though, of course, the economy has grown very significantly during that time. Another thing that people point to is sort of what the capital markets actually look like on the public side. Now we have a much more concentrated public market. So the 7 biggest ones represent 30% effectively of the market capitalization in the public markets. And so we have these very, very, very large companies. The small public companies are sort of disappearing. And all of this leaves us with really important questions that, folks are trying to think about, which is what might the future actually look like for the public markets? Will there even be public markets going forward? And if there are, what are the different ways in which the public and private markets are going to interact, and which ways are they already interact, including, and this is where this paper is especially helpful, what are the many ways in which we have investors who are thought to remain mostly on one side of the public-private divide? What happens when they cross the divide? What are they doing? How is that helping or hurting? And so again, this paper is just a really nice entry point into some of those questions. So my comments mostly have to do with what it is that we are trying to get a sense of with this data on event studies surrounding the announcement of PIPEs involving private equity sponsors. So my comments are primarily that it's very hard for us to interpret the data unless we understand what we are comparing it to, and if we think that in fact we're using the right comparison groups. Because I think, and Elizabeth hinted at this as well, I think there are very different situations here, and what you might expect the market reaction to be would be quite different. And so there's some circumstances where we would say, of course, the market reaction is going to be positive, and others where we would say, we don't know, maybe in those situations it would depend on the type of investor and what role they're providing and so on. So I think we want to think hard about break this down a little bit further in terms of what was the actual situation that led to the PIPE, what kind of company are we talking about, what was the context for the issuance. I think it also matters, and Elizabeth was pointing to this as well, what the particular instrument is, right? Is this truly an equity offering, a follow-on equity offering, which, as we know, in general, the market reacts to negatively, versus is this actually a debt issuance where we don't have the same market reaction, right? So the pecking order suggests that you're going to do an follow-on equity offering last. And so if in fact, if what most of private equity is doing is more something that looks and feels like debt with, of course, a bit of an equity component, then again, it might not be that surprising that the market reaction is somewhat different. And then lastly, I think the reason I'm pushing on this a lot is that depending on the situation, we might have very different views as to what the particular contribution of private equity is. Maybe they are providing some advantage here. It's just a question of what that advantage is. Is it truly their operational expertise, their governance expertise, or is it something else? Is it their financing ability, their ability to close deals really quickly, and to do it with minimal regulatory involvement and scrutiny, something like that. So just to say it a little bit more concretely, in my mind, and this is without limitation, but here are some scenarios in which you would expect to see PIPEs for in public companies. And the one that immediately jumps to mind, because the paper, it's sort of hard to look at the graphs in the paper without it jumping out, is situations where you have a company that actually, just in general, seems to be doing fine, but it is facing a very severe liquidity shock that is driven by something exogenous. So some market shock that has nothing to do with the company itself, but that puts the company in immediate peril. And the paradigmatic PIPE that people always talk about is exactly that case. So this was Warren Buffett injecting $5 billion into Goldman Sachs during the financial crisis. And I think that the examples that the paper gives are very much in that vein. So the travel companies during COVID. So the paper, this is a figure from the paper that shows, PIPE transactions and other follow-on equity offerings. And of course, you see these giant spikes during the financial crisis. That's the first one. And then the second spike is during COVID. And that feels much more to me like just a situation in which the company is really struggling for cash, needs an immediate injection of liquidity, and so finds an investor that can pull this off quickly. Yes, Warren Buffett can do it quickly. He can write that $5 billion check, but private equity sponsors that are sitting on copious amounts of dry capital, dry powder, they also can do that in a hurry. And so that, of course, is going to be welcome news for these companies because it may save them from going under when everybody knows that the company itself is actually performing well. So this got me thinking a little bit. So one of the examples that the paper discusses is Silver Lake and Apollo's injection of capital through a pipe into Expedia at the time of during the COVID crisis at the very beginning of, I think it was May 2020. And so I just thought, well, yes, it's impressive that the stock price went up by 40% in the month after, but what was going on with other travel companies? And so I just pulled at random companies that they weren't random in the sense of these are all ones in the same industry, but I picked ones that were publicly traded. So we have Expedia is the company that is mentioned in the paper, but also I grabbed Booking Holdings, which is basically Priceline, TripAdvisor, and then a hotel chain, Wyndham Hotels, and looked at their stock evolution. And I sort of normalized them at 100, so they were all starting at the initial spot altogether. And the evolution looks very, very similar for all four. And it's possible they all had, private equity run pipes at exactly the same time. But that would be, I think that might have to do with what's going on with the evolution of the stock price here, that it's just more about this was a period where, in fact, the government was putting forward a lot of programs to actually offer COVID assistance. And so that started the recovery of the stock prices that had fallen so much at the time of the initial shutdowns. Okay, so in that situation where we're talking about injection of liquidity, there I think the private equity advantage is not about operations or governance or anything like that. It is about the speed with which they can write a very big check. I think that would be the advantage in those situations. A second circumstance you might run into is a situation where we do have a public company that is in financial distress. Maybe this has been a long time coming due to operations and governance and so on. If you can find some of those examples, that would be helpful, I think, for the paper to show situations where, in fact, you might get an experienced investor who injects capital, but also is willing to take the time to oversee the process of recovery. A third category that springs to mind is these, the pipes are often with small public companies. And the question is, why are they small and what are they doing here, right? So for some of these companies, I actually think there's an adverse selection to the fact that they're in the public markets in the first place, right? Today, there's so much private capital out there that if you're a small company and you still go through with an IPO, that seems to suggest that the private equity funds and the venture capital funds didn't want you in the private markets for some reason. So why is it that they are now suddenly interested? That to me suggests that maybe we should, in those circumstances, actually be worried about private equity involvement. And I'll return to this in a second, because there it might be they're now suddenly interested because they have an ability potentially to essentially siphon off wealth from the other investors. But of course, that's TBD. I'm not claiming that's the case, but it at least raises the possibility. And then the fourth is, I don't think you can talk about pipes in this period without mentioning SPACs and really potentially carving them out from your sample entirely, or at least being very clear about how you're addressing them, how you're making sure you're comparing apples to apples, because SPACs are just a different beast, and those pipes are a very different beast. And of course, we know how SPACs worked out for investors. That was not exactly a shining moment for the capital markets or for the law firms who were pushing them. But in terms of thinking about the role of private equity here, I think we need to know how SPACs are being included in the sample or not. So I will conclude very briefly and talk about one final point, which is I think Brian and Elizabeth were pushing you and with the suggestion that maybe what we're seeing here with these pipes, there's really not actually much governance going on, that the governance rights are actually fairly minimal and they don't intend to use them. They're really sort of just making an investment here and then sitting around and hoping to get out at some point. But there is another possibility. So if you truly believe that they are actually getting really deep into the weeds and getting involved in governance when they're making these investments, then I'm not sure we can say, and the market seems to think that that's a good thing, and so therefore it's fine. I think what we need to say is that if that's true, that they are getting involved in governance, how they behave might change significantly post the Moelis amendments and post SB 21, because now there will be much more clarity around when they might potentially be liable for things that they do. There's less risk for them about getting very involved in governance. And so that could be very good. They might be more willing to engage, which might be a good thing. They can lend more operational expertise and so on. But as we all know, it's very hard to improve companies. It's a lot easier if you have the ability to just transfer wealth from other investors, if you have the ability to do that. And so there is that risk now that this world has changed. And so I think a discussion of that in the paper of what your predictions are for all of this post SB 21 would be quite helpful. And I will stop there.
Those are really terrific, right? So Gabe, do you want a couple minutes to respond before we open it up to general discussion?
Sure, thank you. So thanks so much to Elizabeth and to Brian. Those were all really helpful comments. And some of the things are and I'd love to hear everyone else's thoughts too. Some of the things are things that Jeff and Vartan and I have struggled with, which is to what extent is this about financing versus governance? And I think we need to do more to break it down, maybe really focus in on the subsample where board directorships are exclusively procured and say, this could be a story about governance. It does see, I think in general, pipes are part of the robustness of public markets. I think the pipes is a viable form of complex equity-linked financing and debt-linked financing is mostly from the financing perspective, a story of how allowing exempt offerings by public companies means that during COVID, you have one other option for an extremely expeditious infusion of capital. So there's always this possibility. Ed Rock wrote this paper about the dark side of relational investing. Once we find it, is it going to be bad? So I think we need to keep that in mind, right? The relational investing is not an inherently, it's a characterization of long-term engaged investing. It doesn't mean it's long-term engaged investing that results in an equitable division of surplus from the relationship amongst all the various constituencies that can be involved in a firm. But so far, we don't find things like unusually large discounts being procured by PE firms. So we're keen to see if there's a dark side to this relationship when it exists. Couple of things. Completely agree with I think the comments in general. Vartan and I ran the same event study using different both more using different models, but using different ways of merging crisp data and found the exact same thing. So I think the result is real for the announcement, but the Ilya and Lowry paper, I went back and looked at it this week with perplexity at the weird difference in result. And that's when I noticed that they seem to run it on the closing date, at which point our result becomes the same. I was like, oh, that's interesting. They're running it on the actual closing of the pipe rather than the announcement when they first disclose it. And they're finding this very robust reaction. And I ran it on the closing date. And we also, so maybe the market finds the saliency of the actual finalization of the pipe to be much more salient than when the firm first announces, or maybe the commercial database is treated announcement when you're sort of like a firm's like, we're considering a pipe. And the market's like, all right, well, we don't know anything about the terms. We don't know the sponsor. So I want to look into what constitutes an announcement date versus what constitutes the closing date, because the result really seems to change hugely between kind of 0.8% or whatever versus 5 to 7%. So very interesting, worth looking into a lot more. Couple of other quick things. Yeah, I think that, Elizabeth and Brian both talked about the big picture, which is private equity sounds like it's always been big because we heard stories about the barbarians at the gate in the 80s, but it's just astonishingly bigger now. It's a $10 trillion asset class, and it's colliding with public markets and BDCs and evergreen funds, the attempt to create a new class of retail-oriented PE fund. I think that's probably going to succeed. The SEC right now seems really accommodating to the desires of the PE industry to have those retail funds. So the trajectory is that ETFs and PE are the largest growing fund asset classes. So the $60 trillion in investment funds and ETFs and private equity are growing the quickest. And so I think the coalition of private equity and public markets is going to be a really exciting story going forward. And these intimations of PE as a more aggressive, sharp-elbowed institutional investor in public markets, for better and worse, I think is a fun note maybe to end on, since I want to take up all of our time.
Great. Yeah, so I was just kind of to emphasize a point that Gabe made at the very end. So a new participant in markets today, that seems to be, in a sense, an underlying story. Jesse James was famously asked why he robbed banks, and the answer was, that's where the money is. And so it could be that part of the reason that PE firms are engaging in broader ways here is because of the funding that's available to them, and the way that investors see the potential gains associated with an asset manager who's active, as opposed to an asset manager that's passive. And, you know, the BlackRocks, the Vanguards, the State Streets are really passive in what they do, but the PE firms are obviously not. And so we might be getting to sort of see a story about the potential for value of that special sort of engagement. Anyway, with that, let's open it up to discussions from, Ed Rock.
It's a nice project. I think Elizabeth is right that there's a core question whether this is a financing story or a governance story. If you decide to focus on the relational investing side, in addition to thinking about whether there's a dark side, you should also think about the phenomenon that Dorothy Alone-Brava and I talked about in our paper on validation capital is whether there's sort of a governance certification function going on here. The two cases we look at closely are Trion's investment in BNY Mellon and ValueX investment in Microsoft. In both cases, they went on the board. In both cases, they ended up having a very positive effect on the company. What's interesting about both of those cases is in both cases, they took the position in the stock without coordinating that with management, and then became involved. At least that's true of the Trion. I can't remember if it's true of the Value Act. And that's a different way of getting involved in governance than a negotiated involvement. We found no evidence whatsoever of a dark side. And we have some discussion as to why it would be very hard to take side payments in that context. In the negotiated context, if it's really about governance and not about financing, there are obviously much greater opportunities for dark side investing because the terms are bespoke.
Okay.
Okay, I guess I respond, which is I think the validation capital point is right up, like it's something I've thought about. And I think there's the financing story, there's the governance story. There's actually a different kind of selection story that might be going on, which is are PE funds investing in these companies because they're better at overcoming information asymmetries? That's one kind of financing story. Or is it because they're just better at finding undervalued companies sometimes, right? And they're just investing and the company goes up because they're targeting under. So there are a couple of different selection stories, none of which are, they're not mutually exclusive. And to some degree, you have to assume there are a bit going on, all of them, but they're worth looking on. And the validation aspect would be part of the information asymmetry story, right? We're taking at this as a signal that either governance or the greater ability to overcome its information asymmetry is kind of bonding the PE fund with the issue.
Yes, and what would you say who you are, so
Yeah,
everybody
sure.
knows?
Andrew Shapiro, and I haven't had the pleasure of reading the paper yet, but since it covers the arc of my career, which began in leveraged buyouts, which is what we used to call things before private equity, and then several decades as an activist investor, it covers the arc from what the other professor's saying. I had a few comments or things just to flush out. The first off, at least in my past experience, leveraged buyout funds, PE funds, even venture funds, they tend to have a maturity date, call it 8 to 10 years, maybe a follow-on investment, extension tail. And if you're not the first investment made in the opening of the fund, these funds already burned off a few years. So just bringing the finance concept into this, the concept of a PE fund coming into a company pretty much accelerates the terminal value portion of the NPV calculation. And it's just similar to the idea of a company getting thrown into play and the idea that there's going to be a control premium that is a transaction is going to come out where a control premium may play. And I don't know if you can isolate for that or that is one of the arguments. The second arc here I wanted that was brought out was to find a way of identifying what is the new capital being used for. And as Professor de Fontenay had highlighted, there's a variety of different things. Is it on the liquidity issue where it's near term or costly current pay, debt pay down, M&A, R&D, or is it investments resulting in revenue growth? And I bring these all up because as an activist investor, I've been approached multiple times for pipes. And that's one of the main criteria is like, what is the money being used for? Follow the money, okay? And then regarding your governance aspects about how might you measure, I'm just throw out a few things in terms of maybe flushing out the measurement is if once you change the board with a representative of the leveraged buyout firm, the PE firm, is there a measurable way of seeing if there's a change in the rate of board refreshment? Is there a measurable way of identifying improvement in the pay for performance alignment? Okay. Are there measurable ways of looking at enhancement of return on assets, either in cost ratio improvements or perhaps revenue growth? But I don't know if the revenue growth measurement is really can be attributable as much to the governance as much as perhaps cost ratio improvements could be attributable to the governance.
Those are great questions. So this is for you. What is the exit story, right? I mean, when Andrew raised to me is what's the exit? Is it an exit through M&A of the target, or is it exit through a maturity of a debt? Or, I mean, but if it's an equity investment, then how does it exit?
So I was asking Gabe earlier, because I was just asking around just generally about it. And so pipes, most of the pipes that we did, like I just did a rough, talking to 5 partners yesterday, most of them kind of actually get taken out by the company redeeming them, company buying it back, often in like 3-4 years, right? Because most of the pipes have some sort of optional redemption for the company. I think M&A is less typical. It happens, right? The third thing that we didn't talk about is most PE investors, when they make a PIPE, they're locked up for a year. They can't sell it for about a year is what it is. But a lot of times they can sell in the public markets, right? They register the PIPE and they can transfer it. So the one other piece to think about is when you think about relational investing and they're going on the board, they don't always stay on the board, right? Because they may just transfer to somebody else. And so there are different ways you can get out, right? M&A, you could get out M&A, you can get out the company actually taking you out, which I think is the most typical. Or you can just transfer in the market, right? If it's not doing well. And so when you think about I was talking a little bit about like the different return thresholds of a PIPE versus a control deal and why different funds actually often make these investments because they have different return thresholds. In some ways, a PIPE is an easy investment. Like there is built-in liquidity, right? Versus a control, when you take a company private and you either have to IPO it or sell it, there is a path to liquidity in a PIPE. It may not be a great return, but you can always convert and sell out. And there is like the downside being capped. But one of the things, I also wanted to raise when we're talking about MOLIS and like why you put a right in a shareholders agreement versus the certificate of designations. Are those control rights personal to the investor themselves, like personal to the Silver Lake in your example? Or is it a term of the security that anyone who owns more than 50% of the security can exercise the right? So when you think about relational governance, do the rights actually transfer with 50% of the security in the COD, or is it personal to the original investor? And I think that's something you should look at too when you're.
Could I add a cynical
Yeah.
follow-on, which is perhaps also the issue of with PE versus an activist investor? I don't think activist investors are there for what some PE firms might be there for, which is perhaps, I don't know if we want to call it the Trojan horse, but it is certainly the ultimate in due diligence de-risking and then becoming the stalking horse. In other words, you're in there, you're on the board, you got all, and then, at some point you make the bid. Of course, you're allowing to go shop and you're allowing all the various aspects fiduciarily, but it is the ultimate in de-risking due diligence for a takeout.
Right. All the way in the back. Identify, please.
Michael Schrade with MIT Sloan. That question sets up the question I wanted to ask Professor Broman on this, because you talked about the importance of signaling. But what you didn't say is that oftentimes threat is a very important signal. And you can get a lot of influence by doing things that signal threat or the willingness to escalate. And so I'm just sort of curious, any insights in regards to where you feel you hit diminishing returns on influence and then you kick in to actual control? Because if I can get a lot of influence at relatively low cost, that's what I'm going to do. I'm going to use that activist investor, et cetera, et cetera. So I'm just sort of curious why you didn't double down on the role of threat for sending a signal.
Okay, or Brian, one of you. Yeah, good. Yeah.
Yeah, I guess there's a temperamental. I'm temperamentally just not somebody who starts off looking for the dark side, and I realize that there's just a difference in temperament in how people. So I start off being like, how is this a useful thing in markets? Pardon?
You've been an academic for how long?
Only 8 years, Yeah, I have time. The overripen or whatever the right metaphor is. So I like, if you want to look for the threats that seem to materialize into a dark scenario, Voigt versus Metcalf is a Chancery Court decision dealing with a PE PIPE where the private equity fund becomes the controlling shareholder. It winds down its position, but it still retains enormous influence on the board. Maybe it has a near majority. Some friends of them are also on the board. And then there's a merger, a shock at a price that seems pretty low, given that the company is then acquired by someone else for twice as much a couple months later. So, there's some stories which seem ripe for, private equity does some useful things, but sometimes it really seems to work out well for it, right? So I think that the threat story is just not something that's easy to see in the base rate, so to say. Like when you look at the aggregate data, you're like, okay, like none of the like purchase prices seem like PE systematically gets a better deal than other pipe sponsors. And so looking at the evidence as a whole, you're like, all right, well, we're going to have to dig in and you know, see whether there's some there's probably going to be some like, you know, pretty interesting incidents in there. But at the architectural level, the pipe market for private equity sponsored deals just doesn't have like obvious indicia that the PE sponsors are exploitatively extracting better terms than other sponsors in general.
Would Ms. Cooper agree with that?
So, sorry?
Sorry.
Yeah, so I have another factual question for you, and that is, I mean, you had suggested that there were perhaps funds raised for PE investments as opposed for pipe investments as opposed to others. So is the fee arrangement the same?
There's lots of fee arrangement generally, yes, is the same, right? Because or slightly different. Like again, like, but it's the fee arrangements sometimes are the same, but you're sometimes targeting different investors, right? Because again, like, and I'm not a fundraising expert, but what I said is you often have in like, you have a mix of like a tactical opportunities fund, or like most of PE firms now are multi-strategy, right? And so if you look at the big multi-strats, they have a main buyout fund, right? They have a strategic investment fund that does different types of investment. They have an infra fund, they have an energy fund, they have a growth fund, right? And these all have different return thresholds. And investors are looking for a more diversified product. And a lot of times investors are going into multiple products. And so is the overall fee arrangement the same? Yes, it is, right? But it also, there are negotiated like waivers and fee rates and other things. So, but generally speaking, yes, the fees are the same. It's the same 2 and 20. It's just that like you might be getting more consistent returns, and you also might be getting them earlier, right? So while the short answer is yes, but it's a little more nuanced. I don't want to get into it, and it's not consistent across firms.
Right. Well, that's great. Anyway, so we're at the 10:30 time, and so we have a well, first, bravo to presenter and panelists. I think that was really informative, right, about a new development, and that's, I think, the value added to coming to an event of this sort, learning what the news is. And a nice mix of practitioner experience and the academics who have deep knowledge here. Thank you, Elizabeth, and Brian. So we'll take a 10-minute break, but only a 10-minute break, not a 10 and 20 break, but only a 10-minute break. And we'll resume for our next panel, which is on Dexit. Sort of a topic of the day. So thank you all to the panelists.